next speaker. Our next speaker is Sebastiano Nessi. He's an international arbitration and dispute partner at Curtis in Geneva. He has appeared as counsel in some of the largest commercial and investment treaty and sports arbitrations of the last decade. Sebastiano, who taught dispute resolution and arbitration at the University of Paris 1 Panthéon-Sorbonne, also sits frequently as an arbitrator. Sebastiano is a fellow of Chartered Institute of Arbitrators and is recognized internationally in all major directories and publications at the top of the arbitration market, who legally recognize him as a global elite thought leaders in arbitration under 45. Dear Sebastiano, after this short presentation, I think all our audience ask themselves only one question: how it's possible to achieve such results under 45?
That's very kind of you, Alexei. That's a good point. I'm myself wondering. Perseverance, I guess, and a lot of work and very short nights. But no, thank you so much for the kind introduction, Alexei.
This kind is the topic of your presentation: force majeure, hardship, necessity, addressing unforeseen events in a changing world. Yeah, you're welcome.
Yes, exactly. So I will try to now share my screen. There you go. So wait, display set swap. Can you see my PowerPoint presentation?
Yes. You see it.
Fantastic. So yes, broad topic. I wanted to address that topic because I think that it's a very topical issue. So today we'll discuss about force majeure, hardship, necessity, and PMs, and how to tackle unforeseen events in a changing world in arbitration. What I will do today is to discuss both commercial arbitration and investment arbitration, because I think it's good to know how those defenses are being used in both sectors. So maybe let me start with the context. I think we all know the context. And today the question is, how do you address unforeseen events in changing world, such as substantial devaluation of a contract currency? I mean, this is something we've been all faced, recently. Regional or global financial crisis, civil riots, armed conflicts, wars, state embargoes, sanctions, pandemics, all of those issues, which I guess sound very much familiar to most of you, of course, have a tremendous impact on contracts, state contracts, contracts between private companies, and eventually arbitration. So let me start maybe with what is certainly the most common defenses used in that context, which is force majeure and hardship. And here what I will do is basically explain or give you the basics before giving you examples of commercial arbitration and investment treaty arbitration, so that we make sure we cover entirely the topic. So what are we talking about when we talk about force majeure? You probably all know, so I will be rather concise on this, that force majeure is a doctrine under which a supervening event may excuse liability, and that's very important, for non-performance of a contract. So basically you have the impossibility to perform the contract, providing the supervening event is, and here you have three conditions: unforeseeable, that's the big question, beyond the party's control, and that this event make the performance of an obligation impossible, either on a permanent basis or a temporary basis, but not simply more onerous. And this is very important. We're talking about an impossibility within the execution of the contract. I've put here, you know, Article 1 of the ICC force majeure clause, 2020. You'll see here on the screen that we are talking about those three conditions: beyond reasonable control, unforeseen at the time of the conclusion of the contract, and of course, that the effects of the impediment could not reasonably have been avoided or overcome by the affected party. So what's the difference between force majeure and hardship? We've seen that force majeure basically means that it's impossible to perform the contract. Now, when we deal with hardship, it's a slightly different theory, because with hardship, you deal with cases where the agreed performance of the contract is still possible. But, and there's a big but, the underlying facts have substantially changed, and it makes no economic sense for one of the parties of the contract to perform the contract. So why is it important to differentiate between these two theories? It's very important because the legal consequences are very different. In force majeure, as we know, a party cannot fulfill its contractual obligations. So you cannot deliver oil, you cannot deliver gas, you cannot deliver a good, you cannot deliver any sort of obligations you have committed to deliver. And with force majeure, when it's argued successfully, of course, you are relieved from the obligations you had to perform during the time of force majeure, unless there's a permanent impediment. And that's what we call, for instance, in the French Civil Code, the effet libératoire. Why am I saying that? I'm saying that because, as you know, most of the theories I'm discussing now, I'm discussing them on a general level. But depending on the applicable law to the contract, you will have different applicable theories. Force majeure is a theory, for instance, which is unknown under Swiss law, which is the law I'm qualified under. But it is known under French law, which is also a law I'm qualified under. So I know those two laws quite well. But force majeure itself is unknown to most civil law, common law jurisdiction. So we are dealing, you know, with different topics. So here I'm not entering into the details of all, you know, of the state law applicable, potentially applicable to a contract, but I give you an overview. But never forget that it's important to look at the law applicable to the contract, of course. So that's regarding force majeure. Force majeure, the legal consequence is you are relieved from your obligation during the time of force majeure. When it comes to hardship, you're not relieved from your obligation. What you will ask the judge is to change the terms of the contract or to terminate the contract. So which means that you will go to the judge or the arbitrator and say, look, Mr. or Miss Arbitrator, I cannot fulfill my contractual obligations anymore because it does not make economic sense to do that. And I ask you to adapt or terminate the contract. You see the difference? In one case, you suspend the obligation. In the other case, you ask the judge or the arbitrator to change the contract. Now, be careful that in practice, when you have force majeure and hardship clauses in contracts, because of the influence of common law, most of the time those two concepts overlap and they are understood to operate in the same way. So always analyze very carefully, you know, what are the clauses in your contract. And if you don't have any clauses in your contract, look at the applicable law to see what the principles you could invoke in your situation. Now, having said that, I will give you two examples: economic sanctions, pandemics, economic crisis. So if I take economic sanctions, I know that others will address that, so I just use it in the context really of force majeure and hardship. Are economic sanctions and embargoes force majeure or hardship event? So what do you have generally in sanctions or embargo? You have either a general ban of any transactions with a sanctioned entity, or you have a provision in the sanctions providing that a claim brought by a sanctioned entity cannot be satisfied. Okay, you can have one or the other or both when it comes, you know, to claims to be brought before an arbitral tribunal or a state court judge. So once you have concluded that the sanctions are applicable in the context of your dispute, and those days, of course, we all have many disputes where sanctions have an impact on the disputes, it is still necessary to assess whether it satisfies the requirements of force majeure event if we take a force majeure argument. And here, for instance, if you have the possibility to seek a license regime, for instance, you could potentially argue that the sanctions may not constitute a force majeure event if a license can be successfully sought. And you also have situations where some force majeure clauses in the contract includes a requirement that a party uses its reasonable endeavors to avoid or circumvent the effect of the force majeure event. And here, if you have such clauses in your contract, you could, for example, argue that if you have to pay in a certain currency, that it may be possible to make payments in another currency or to take other specific steps to continue to performance the contract in compliance with the sanctions regime, of course, if that's possible, to avoid force majeure. So what I mean by that is that if you consider that the force majeure, you know, elements, or that we are in a situation of force majeure, you still have to look at those elements. Now, what are the available remedies in the context of economic sanctions? And here I set out what I consider to be my position. And of course, I fully understand that some other scholars or arbitral tribunals might disagree with that, but I think it is a rather reasonable approach of things. Economic sanctions are temporary in nature. So I would say that in the context of force majeure, because with the force majeure arguments, we try to suspend or stay the obligation, I consider that an obligation in that context might be suspended, but not discharged. So basically, you suspend the obligation during the time where economic sanctions affect your contract. Now, of course, the importance of the length of the delay might have an impact on the remedy you seek or on the execution of the contract. Now, if at the time when the sanction is lifted, the affected party's performance became meanwhile substantially more onerous, and the performance would be radically different from the original contract, or the other party, the counterparty, is no longer interested in receiving the performance because of the passing of time, then the contract may be terminated under the force majeure clause or under other various doctrine, frustration, impossibility, or hardship. You know, you remember hardship, basically there's such a difference within, you know, the underlying facts of the contract that it makes the performance of the contract not possible anymore. Now, that's the theory. As I said, in practice, you have many contracts that are governed by certain national laws. And under certain national laws, you don't need to wait until the sanction is lifted to say, look, now I want to terminate. But as I said before, you can try to terminate the contract if you can show that not only it is impossible to perform during a certain period of time because of the sanctions, but that the fact that those sanctions will be imposed over a certain period of time, or are likely to be imposed over a certain period of time, this made basically the execution of the contract for the future impossible, and seek termination of the contract already at the time you have a dispute arising. Okay, so those, you have really different scenarios, and it will very much depend, you know, on the facts of the case. Now, pandemics and financial crisis, very important, of course. We have seen the COVID-19 pandemic, but I can tell you, I mean, everyone is saying it today. COVID-19 was one pandemic, but there will be more. There will be more with time, so another pandemic might arise. So in that context, I guess, we have a lot to learn from what happened with the COVID pandemic. The COVID pandemic was considered as a classic example of force majeure. And force majeure event is, of course, not the pandemic as such. It is the factual and the legal effects of the public health crisis. So what are we talking when we say factual effects or legal effects? Factual effects, for instance, involve illness, quarantine, death of key personnel, production facility closures, interruption of supply chains. Legal effects, lockdowns, curfews, travel restrictions, or any other kind of measures imposed by governments or public authorities in reaction to the crisis. So that's typically, you know, the situation that the COVID-19, you know, created. But you could also argue, and in several cases, COVID-19 was considered as a force majeure event. But you could also try to argue that you have a sort of hardship in the performance of the contract. Of course, if you have a situation which is such that we're not talking about, let's say, a temporary impediment in the performance of the contract, but such a change, you know, at the origin of what the parties of the contract, that the contract must be adapted. And here it's very important that you characterize properly if it's force majeure or if it's hardship, because as we said, there are different conditions and there are different remedies. In what case you suspend the obligation, in the other case you modify or you terminate the contract. Now, financial crisis, I will say a few words afterwards on that. But keep in mind that courts and arbitral tribunals, especially in commercial matters, are very much reluctant to excuse contractual non-performance based on claim of economic hardship and changing economic conditions, financial crisis. But I'll say a few more words about that, because force majeure and hardship are difficult arguments to make in those circumstances, but there might be some other legal theories. Now, I said I'm talking about commercial arbitration, but I am talking also about investment arbitration. So I will give you just an example of force majeure in that situation of unforeseen events. Force majeure defense, and I'm talking here about contract claims. You know that in investment arbitration, you have either purely international law, public international law claims, or you have contract claims if the state has entered into a contract with a foreign investor. So here I focus on contract claims because otherwise we don't have time. So force majeure defense excuses states from the obligations to perform the contract where the unforeseeable event is beyond the control of the state, of course, and makes the performance of the state's obligation materially impossible. Let's bear in mind that force majeure and hardship, that's the same, is not a basis for a state to defend affirmative measures that the state chose to adopt. So if a state does something, takes a measure, you cannot say force majeure. You will use other theories that I will discuss later. Force majeure is the way to defend yourself in light of a situation where the state doesn't do anything, but the state cannot perform. So I give you an example, for instance, of what we call civil unrest. In 2003, Venezuela was in a very, turmoil situation, and there was a huge dispute regarding to road tolls. Okay, so basically, you use the roads, you have to pay tolls, and those are privatized. And the question, was how does this work in the context of social unrest? And Venezuela tried to use the force majeure arguments to defend the claim relating to those road tolls claims, because there was at the time a huge civil unrest in the country. The country was going through a very difficult political time and social time. And you see, the threshold of force majeure is so high that the arbitral tribunal considered that indeed Venezuela could not, because of that civil unrest, comply with its contractual obligation to increase toll fees because of the civil unrest it provoked in the country, but considered that this event was not unforeseeable. And in many cases, the foreseeability or unforeseeability requirement is a very, very difficult one to prove. And with COVID-19, it passed the test on unforeseeability because it was rather clear that no one could have expected such a global pandemic with such a global effect, okay? But in case of civil unrest, it's much more difficult to prove that. Now, how investors can use force majeure in contract claims. You have a case, RSM versus Central African Republic, where basically it was, I don't give you all the background because again, it takes too much time, but basically we're talking about licenses, okay? So licenses given by the state to exploit certain natural resources. And the investor invoked force majeure to justify its non-performance of certain contract obligations vis-à-vis the state because of the political and security situation in the host state, being Central African Republic. And what's interesting in that case is that the tribunal confirmed indeed that the security situation in that country was so bad that not only as a matter of principle, it was covered by the contract's definition of force majeure, because there was a definition of force majeure in the contract we've provided for political unrest. But it held also, interestingly, that the conflict situation in that host state, in light of all of the circumstances, was indeed unforeseeable. So here you could say, okay, we did most of the job, we've proved most of the requirements, the defense should work, but the tribunal said, and you'll remember what I said before regarding whether you are completely or not prevented from doing something, because that's what has the heart of force majeure. It's an impossibility. The tribunal suggested that the force majeure situation in that case did not suspend all obligations under the contract. And one of the obligations to seek licenses, the tribunal said, I agree that now you cannot seek licenses, but 2 months ago, you could have sought licenses, and you should have sought licenses. And because you have not done that, then the force majeure exception cannot be used and does not cover all of the obligations of the contract. Now, let's move to necessity and NPMs, non-precluded measures. Here we're going to focus on states, because doctrine of necessity and NPMs is not a doctrine that is applicable or in the context of commercial arbitration. Now, necessity defense. I will say a few words about that. Necessity defense is a theory you can find in Article 25 of the Articles on the Responsibility of States for Internationally Wrongful Acts. Necessity defense is a defense you can invoke when 4 conditions are met. And not only I will present now the conditions, but I will raise some concerns with regard to those conditions. And I'm wondering whether at the end of the day, this necessity defense, article should not be changed. Of course, I have little hope that it will be ever changed. You can allege the doctrine of necessity. And basically, the doctrine of necessity is the doctrine that you use when the state does something. So it means that the state takes an action which basically impedes the investment of a foreign company. So it's not like force majeure that the state tries to defend itself. Here, the states take decisions, make an action, do something. So in those circumstances, basically, you can try to use the necessity defense if you have those 4 requirements. First of all, the measures can only be taken by the state to safeguard essential interest of the state. But, and that's my concern, there's no qualification as to what makes the interest essential or whether such interest is limited to traditional security concern. And this is, of course, left for arbitral tribunals to interpret. There must be, that's the second requirement, a grave and imminent peril against which the measure has been taken. But, and here is my concern, when can an economic crisis, a financial crisis, or a pandemic become imminent? When can this culminate into a grave and imminent peril? At what point in time does the state has to act? If the state takes precautionary measures, is that basically a breach of its obligations? And does it lead to indemnifying the investors? No, again, question marks left to the arbitral tribunals. And we know that when it comes to investment arbitration, arbitral tribunals tend to take, complete different positions. The chosen measure by the state must be the only way to beat the objective. That's the third condition. But how do you assess that, where there often exists a multitude of ways to meet the objectives in such situations? And the fourth one is that the state should not have contributed to the emergency situation. So of course, for a pandemic, that's easy, but let's talk about a financial crisis. Remember about the financial crisis, of 2008, 2009, the one of 2000, 2001, the current one, financial and energy crisis. What does it mean that the state should not have contributed to the emergency situation? If you have a financial crisis, you could argue, look, if banks had higher capital, the crisis would not have occurred in the first place. If the government had taken measures earlier, the crisis could not have been contained. All of those arguments could be made to basically shift the blame to the state and said, to a certain extent, you have contributed to this decision by maybe taking bad political or economic decisions. So my question is, are states potentially responsible for any act by failing to anticipate or contain an emergency situation? Now, NPM clause. NPM clause, you have that in certain bilateral investment treaty, multilateral investment treaties. What does it say when we talk about NPM, so non-precluded measures? It's very much diverse, and it very much depends on the wording of your bilateral investment treaty. I just gave you here 2 definitions. One is from the Comprehensive and Progressive Agreement from Trans-Pacific Partnership, and the other one is an example from the India-Mauritius Bilateral Investment Treaty. So in the first one, what does it say? It says that nothing in this agreement shall be construed to preclude a party from applying measures that it considers necessary for the fulfillment of its obligations with respect to the maintenance or restoration of international peace or security, or to protect its own essential security interest. In the India-Mauritius, you have a rather similar definition, which basically says that the bilateral investment treaty shall not in any way limit the rights of either contracting party to apply prohibitions or restrictions of any kind, or take any other action which is directed to the protection of its essential security interest, or to the protection of public health, or the prevention of diseases in pests and animals or plants. Now, let me finish with 2 examples. Now, we've discussed the pandemic example with force majeure and hardship. Now, let's see how do we interpret, pandemic and other unforeseeable events with necessity and NPM clauses. Typically, states, you remember, have adopted a variety of measures in the past and still do. If you take, for instance, China, I mean, they still do adopt measures currently to respond to the health and economical crisis caused by the COVID-19. And most of these, of course, decisions impacted and still impact foreign investors. What are we talking about? Price regulation, export restrictions, suspension of payment, seizing of private property, compelling production. So in those cases, the state might try to basically use the theories of necessity or NPM clauses. Under the NPM clauses, if you have one in the treaty, you can basically say, look, I have an NPM clause. As in the India-Mauritius BIT, I'm allowed to take measures to protect the health of my citizens. And if I take those measures, I'm justified to take them, even if it impacts foreign investment. So the NPM clause allows the state to respond to these extraordinary circumstances by taking those measures that would otherwise be inconsistent with their obligations under the BIT. And of course, the successful invocation of those NPM clauses will remove some state measures from the substantive provision of a given international investment agreement. Now, you can also try to argue as a state that there was some necessity to take those measures, and that necessity will excuse the states from the responsibility when its actions are the only way, of course, you remember, to safeguard an essential interest from grave and imminent peril. Now, the necessity defense was invoked by Argentina, and I will finish with that example, in its response to the country's 2001 debt crisis, okay? And that's a very, very interesting example, because here we're switching from pandemics to financial crisis, okay? Or you can apply that also to civil unrest, to sanctions, to all of those unforeseeable events. But the Argentinian example is a very good one. You remember that in December 2001, January, February 2002, it was an absolute nightmare, politically speaking and economically speaking, in Argentina. Presidents were changing, at an unusually fast pace, and Argentina had to take radical measures because its country was basically facing bankrupt. So what do? They restricted bank withdrawals. That must sound familiar, because those measures are also taken by other countries now. They prohibited fund transfers abroad. They abrogated their convertibility law, peso dollar, and they liquidated the value of foreign investment. So Argentina was bombarded literally with actions from foreign investors because of those measures. And Argentina said in all of those cases, look, the situation was such that I was in grave and imminent peril. I had to take those decisions. And you have basically here two sets of tribunals which have taken different approaches. The tribunal in CMS, Enron, Sempra, Metalpar, Suez, Total rejected the state of necessity pled by Argentina, and only two tribunals, LG&E and Continental Casualty, accepted the defense. In these cases, the LGE and Continental Casualty, the tribunal found that in light of the aggregate of devastating economic, political, and social conditions, the measure was essential for safeguarding the essential public interest of Argentina. But in all of the other cases, and for instance, in CMS cases, the tribunal said with the same facts that no, it did not give rise to a state of necessity because it did not result in total economic and social collapse. So what's interesting, and I conclude by that, is that in this case, it shows you how investment tribunal interpreted differently the same concept to exactly the same situation. So if you're a state or an investor, of course, seek advice from professionals, because all of those issues are not only very complex, but you can see that tribunals take different approaches depending on those cases. And with that, thank you so much. I know that's been way beyond my 20-minute Alexei. I deeply apologize to all of you. It was really a pleasure to exchange today and be present. And again, thank you to the organizer for this fantastic event.
Thank you, Sebastiano. Thank you for our report. I ask you to send your presentation to us, because we'll definitely recall these provisions many times in the future. Thank you.